We will begin discussing employment law. Well, make sure you understand what we discuss in this podcast, but we definitely don't need to go into all the detail that our chapter explores. It's not that anything in the book isn't right, it's just that there's a lot of detail in there. And I don't think it's helpful to understand something on that level when we simply don't have the time to go into it that much. Let's just leave it that if it's not in the podcast, then it's a topic that you don't really need to know. Let's look at the topics that we will be covering. First off, just a reminder, we're talking about employment law. So that applies only to employees. If we're discussing independent contractors, it won't apply. We are just talking about employees. First off, we're going to talk about legislation protecting workers' health and safety. Second, we'll talk about legislation that protects wages, pensions, and benefits. Third, but we're going to put this on a different podcast, we are going to talk about equal opportunity legislation. Fourth, we'll talk about employee privacy. And finally, fifth, we'll talk about job security. Okay, let's take out our first topic, legislation protecting workers' health and safety. First off, be aware of workers' compensation insurance requirements. These are state requirements that employers maintain insurance policies guaranteeing workers' health and safety. So, a workers' compensation policy covers employees who are injured while working. You can tell the kinds of disputes we're going to get. You're going to get debates about whether someone was really an employee or an independent contractor, because workers' compensation simply covers employees. Then you get debates about whether the employee was really working at the time they were injured. There's a lot of litigation about workers' compensation, and it's often not well managed across different states. There's a lot of fraud in the system. And finally, it's a state requirement that employers maintain such insurance policies. Remember that this insurance policy doesn't have anything to do with liability. So if an employee is absolutely disobeying given instructions by the employer and then he's injured at work, he's still covered by workers' compensation insurance. The classic example is this. Suppose you work at a gas station. You're employed at the gas station. What's the one thing you should never do around gas? Smoke. Let's suppose that your employer has warned you of that. Let's suppose there are signs all over the place. There are instructions that your employer told you never to smoke. And despite that, you light up a cigarette and you smoke. And you blow up. Were you injured while working? Yes. Again, it has nothing to do with liability or assumption of risk or anything. It's just an insurance policy. The equivalent would be, think if you were drunk and it was dark and you stumbled down the stairs at home and you broke your ankle. Let's say you're lucky enough to have medical insurance. Are you covered for your broken ankle? Yes. Why? Well, because you have insurance that pays for the cost of your health care. They're not going to ask how stupid you were in breaking your ankle. You're simply injured in a way that falls within the terms of the policy. So remind yourself, workers' compensation is simply an insurance policy. The legislation that covers workers' safety on the job includes OSHA, OSHA, and the state equivalent for that in California is called Cal-OSHA. It basically allows either the federal or state authorities to come in if there's a complaint about workers' safety and to require that the employer make the workplace safe, and even to shut down the workplace until it is reasonably safe. It allows employees to file complaints. They can make sure they have safety in the workplace. The Family Medical Leave Act, FMLA, is something that permits leave without pay for employees with larger companies. Those are at least 50 or more employees, and it kicks in whenever an employee has to care for a new child, or if someone in your immediate family, like a spouse, child, or parent, has a serious health condition, or your own serious health condition. In general, this is only going to apply when the employee's other benefits have been exhausted. So, for example, first you would want to exhaust your own sick leave because you're getting paid for that. Why would you go without pay if you didn't have to? So, this is sort of a safety net of last resort. If you've already exhausted everything, sick leave, disability leave, anything else, it does require that larger companies basically hold your job for a certain amount of time while you help your family or yourself with a serious medical problem. The employer's defense would be is if they had a reasonable belief in denying the leave. Let's go to our second category of legislation that helps employees, and that is legislation protecting wages, pensions, and benefits. We don't have to spend too much time on this. You're probably pretty aware of it anyway. You're aware from your own wage statements that you have deductions for Social Security, Medicare, health insurance if you get that, unemployment compensation, SSI gets withdrawn from your paycheck, for example. These are things that everyone's pretty much aware of if they've been employed. Most people are aware of minimum wage and overtime provisions, so we won't be spending much time on this. With problems like these, you really need to call an HR professional to make sure you comply with the law because there are a lot of technicalities. The most that we're aiming for in this class is that you're simply aware that such limits exist and you know when to pick up the phone. ERISA, E-R-I-S-A, is a federal program that is designed to protect pension plans. It's sort of an insurance program so that private pension plans remain funded to a certain degree. What the fear was that people who invest in pension plans in their companies, usually those pension plans invest most or all the money into the stock of that company, and that's fine as long as the company is doing well financially, but if the company goes bankrupt, what happens to all the money people have been saving all their lives for with their retirement? Just disappears. ERISA is supposed to give a bit of a safety net there. Finally, unions, to the extent that they may apply in the workplace, which is less and less common in private industry. Over time, it used to be that a significant proportion of employees with private employers were unionized. That's much less true today. There's been a huge decrease, probably because of the rise of legislation that protects workers' safety and benefits. So unions are not needed as much as they were 100 years ago. You see a rise in activity with governmental employees for reasons I could go on about, but I won't because it's not especially necessary for what we're doing. I'm going to skip over equal opportunity employment and talk about it in a separate podcast. But as a reminder, this is a huge and important area of law. Employee privacy is our fourth topic, and this one's an important one. What's happened increasingly is that employers are in a rough position because suppose that you're worried, and you should be worried, that your employees might injure a third party or a customer or something like that. Should you be worried about that? Well, yes, you should, because now you know about respondeat superior. If the employee was working at the time, the employer is going to have to pay the cost of any such judgments. And you're also going to be paying workers' compensation insurance on these people if they're out because of an injury. You may have increased cost of health care and insurance premiums. There may be OSHA liability. So there are all kinds of good reasons why employers are worried about employees behaving safely on the job. Now, what some employers have done is to start instituting drug testing to at least reduce the risk that employees will engage in dangerous activities while working. Well, now there is a problem because employees also have privacy rights, and when you start doing random drug testing, are you invading their reasonable expectation of privacy? So, in a way, employers are in a catch-22 because they want to make the public safe and reduce losses for their own company, but at the same time, they have to honor the employee's privacy rights. So, what can employers reasonably do with regard to drug testing. Generally, a court will uphold drug testing if the employees are applying for a job. It is considered reasonable at that point. It's also considered reasonable if there's some suspicion that the employee is using drugs or alcohol. If public safety is an issue, or, for example, after, let's say, a bus accident, it would certainly be reasonable for the employer to require the bus driver to take a drug test. So just realize that you're in kind of a touchy area here. You want to test when it's reasonable to do so, but not so much that it looks like you're trying to interfere with your employees' lives and rights of privacy. Another topic separate from drug testing is that there are some other privacy rights that have become an issue in the workplace. It used to be very clear in many jobs when someone was working and when they weren't. People worked at the physical location or workplace, and if they weren't there, they weren't working. Well, how many of you have worked at remote locations, not from the work site? Probably all of us. How many of you have done work from your own personal cell phone on your personal iPad? And contrast that with how many of you have done personal tasks on a company computer or perhaps a company-supplied phone. How many of you have checked personal email on a business computer or gotten personal emails on your business email? It's all becoming very blurred to determine when we're working and when we're not working. And as you work your way up the management ladder, it's going to get more and more blurred, because at the lowest level, it's easy to say, oh, it's 5 o'clock, it's the end of the day, you're not working. That's not so true once you reach the middle and upper levels of management, when you may be working evenings and weekends. It's awfully hard to say exactly when someone's working and when someone's not. So, with all of this said as a preamble, is it an invasion of an employee's privacy that the employer looks at their email and their other material on their company-sponsored computer? In other words, does an employee have a reasonable expectation to privacy when they're using the company's computer? The initial response would be, no, you can't reasonably think that, because it's company property. You can't really think that it's not ever going to get looked at. Because of the blurring of business and private lives, it's gotten a little bit harder to tell. So, for example, companies that allow internet access or allow people all the time to send non-business related email, are they impliedly agreeing that it is okay to sometimes use a business computer for personal use? Well, what many companies are doing is saying that the company email systems can be used only for business email, not for personal use. And if this is the result they want to notify employees that they want computer devices, whether laptop or tablet or phones, that they may be monitored. So if a company wants to be able to do that, they need to warn people. Because otherwise, the problem is that employees will claim that they have a privacy interest. They're going to say it's an invasion of privacy to be checking on them. Recall that for invasion of privacy, the test is, did the plaintiff have a reasonable expectation of privacy? For employers who want to be able to monitor such activities, they need to notify employees that the employees should not have an expectation of privacy. Finally, on this podcast, we will talk about job security. Compare the right to terminate the employment relationship with the power to do so. The right versus the power. Everyone always has the power to terminate an employment relationship, but it might be in violation of their agreement. So that's the problem. You need to know the difference between employment at will and employment for a term. With employment at will, at least in common law, it meant that you were employed as long as both parties willed it, the employer and the employee. Employment for a term, on the other hand, is for a specified time. Almost all employees are employees at will. Employment for a term would be, for example, well, my job. I have a contract with the university. So even if I want to walk out right now, I can't legally do that. Why? Because the university wanted to make sure that I didn't just leave you guys in the middle of the semester and say, sorry, you won't get credit this semester. They need to guarantee that I'm promising to stay for the end of the term. So we entered an agreement that I would stay until the end of the term. Do I have the power to terminate that agreement early? Yes, I have the power, but it will violate the contract and they can sue me for damages. And vice versa, I can sue them if there's a termination outside the meaning of the contract. Look for people who have a lengthy contract, let's say 3 years. They have an employment contract, which is very common, especially at upper levels of management, or to complete some particular project. For example, you may be employed for a particular project because the need to guarantee that you will be available through completion of that project. That would be employment for a term. And they can breach it, but then they can be sued for breach of contract and pay the damages. Again, though, most employees are not employees for a term, but rather employees at will. If you wanted to, could you go to your employer right now and say, I'm done, I just don't want to work here anymore, I'm giving my notice? Do you have the power to do that? For most of you, the answer is yes, you could do that. How about your employer? Does your employer have the power to do that? Could they just say, you know what, we don't have a very good reason for this, but we just don't want you here anymore. It's not your work performance, it's not business conditions, we just don't want you here anymore. The answer in common law was yes, because it was completely reciprocal. The same reason an employee could terminate for a good reason, a bad reason, or no reason, so could the employer. In more recent times, on the part of the employer, this rule has been cut back a bit. So with employment at will, the employee can terminate for a good reason, a bad reason, whatever. It's normally understood that the employee must give notice. And I'll tell you the reason for this. When I ask you about giving notice, what's the period required for that? What's your answer? How long? Most of you just thought 2 weeks, right? Think about at what interval you get paid. For many people, it is every 2 weeks. That's the origin of the rule. The idea was with employment at will, payment for each pay period. If you didn't give notice, you were implying to stay until the end of that pay period. So logically then, the notice you should give would be dependent on how often you got paid. If you got paid once a month, you would be giving 1 month's notice, at least at common law. However, back to the bigger problem. Can employers terminate employees for no good reason? In other words, it's not a business reason. It's not that the employee's done a bad job. It's just they don't want you anymore. Can they legally do that? There are some limitations on the employer's ability to do that. First, there's a public policy exemption. And we've seen the public policy issue come up before when we talked about legality. In the courts, whenever conduct violates some policy that is designed to promote a healthy society, courts may simply not allow such conduct. For example, suppose there's a whistleblower case. An employee has alerted government officials or the public to illegal or dangerous behavior on the part of the employer. Whistleblowers are people who can call attention to things that are great public Whistleblowers are people who can call attention to things that are of great public importance. Let's say that your employer says to dump a bunch of hazardous waste, and refusing to do that, you get fired. I'm not sure you would still want to work there. However, there would be a public policy defense if that employer tried to fire you, even though you were an employee at will. Another example would be if an employee files a workers' compensation claim, they don't want for workers to be retaliated against simply for exercising their rights as an employee. So whenever it seems shockingly retaliatory or unfair, a court may well come in and say, no, this is a public policy matter now, and you are not simply free to fire this person for no reason or a bad reason. A second concept that applies to this is that of implied contract. Sometimes there are either employment agreements or company policies that tell people when and how they can be terminated. And if these are not followed, sometimes courts will say there's an implied contract that the employee will not be terminated unless the company follows through with its HR policy For example, let's say a company has a policy that there's a 30-day warning or suspension to try to bring an employee's performance up to that standard. But this time the company didn't do that. The court might say, well, their failure to follow their own rules is really an implied breach of their agreement not to terminate you unless they followed their policy. It's a little bit of a stretch. Take a look of those of you who work at companies that have employee handbooks. Oftentimes, these handbooks will have provisions about how often you get reviewed, the consequences of inadequate performance. Sometimes courts will say you didn't follow your own internal procedures. The company has impliedly promised to do that before terminating someone, and they can't simply terminate the employee without following their own rules. A third rule, and this applies in some jurisdictions, not including California, is a covenant of good faith and fair dealing. This is just the idea that a company is supposedly implying that they'll act fairly with their employees. An example would be, what if you had an employee who had been working at a workplace for 39 and a half years and is going to get his pension as soon as he reaches the 40-year mark. And right before he's eligible for his pension, the company terminates him. This is looking pretty sleazy, and a court might step in and say, absent some legitimate business reason or performance reason to terminate the employee, it appears to be a breach of the company's implied promise to act fairly and in good faith. Now, separately, we're going to come back and pick up the third topic, which is equal opportunity legislation, in our next podcast.